Folks, welcome to episode 3 of Criminal Defense 101. Today we're going to deal with bail questions. So the first question I get is, what is bail? Bail is some type of cash or real estate that you put up guaranteeing two things. Number one, that you will appear for all your future court appointments, and number two, that you're not going to commit new crimes. So, cash or some type of real estate, normally called surety. So for example, the court may order $1,000 cash imposed as bail or $5,000 surety. It's usually about a 5-to-1 ratio between surety versus cash. Now, who sets bail? One of two people will set bail. Either the bail commissioner, for which you pay a $60 fee, or a judge. No one else can set bail. And the judge can be a district court judge or a superior court justice. What happens if you don't like the amount of bail that was set and you can't afford to post it? Well, you have a right to a de novo appeal of the bail to a superior court justice. They will hear a fresh bail argument, and then the judge is free to do one of three things: reduce the bail amount, leave the bail the same, or increase the bail amount. What are the conditions of bail? Generally, bail conditions reflect no new criminal conduct, and oftentimes you give up your right to remain free from unreasonable searches and seizures. That means in many cases the police will be able to search you, your home, or your vehicle without any probable cause or articulable suspicion that a crime has occurred. Just by virtue of being on bail conditions, you can be searched. This is very important, and for most people extremely disturbing. Disturbing both to their lifestyle, to their family, and to their own personal peace of mind. Those conditions should always be sought to be amended, and who needs to do that is your attorney. They must submit a motion to amend bail. Will bail be set in my case? Bail is almost always set in a criminal case. It could be what's called PR bail, or personal recognizance. That means you are giving your word to appear in court at the next date and all future dates, and that you will remain crime-free. It could be unsecured bail. There may be $1,000 or $5,000 unsecured bail, which means, once again, you're not posting money. But if you were to violate your bail, you would have to pay the amount of unsecured bail as a penalty if you ever want to get back out. Finally, how can bail be revoked? Your bail can be revoked. Normally it happens if you've committed a new crime, but it could happen if you've done something that we all like to do on the weekends, and that is consume alcohol. If your bail conditions specifically state or prohibit you from the possession or the use or the consumption of alcohol, and you're out with a few friends down in the Old Port and decide to have a couple beers, if you encounter the police and they find out you are on bail conditions, your bail will be revoked and you will be charged with a new crime. This has been episode 3 of Criminal Defense 101. Keep tuning in, and I look forward to bringing you more commonly asked questions about criminal defense in the future. Thank you. Folks, welcome to episode 3 of Criminal Defense 101. Today we're going to deal with bail questions. So the first question I get is, what is bail? Bail is some type of cash or real estate that you put up guaranteeing two things. Number one, that you will appear for all your future court appointments, and number two, that you're not going to commit new crimes. So, cash or some type of real estate, normally called